Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the sections 130 and 131 of BNS Act 2023. Corresponding law is sections 351 and 352 of IPC. Assault. An assault is something less than the use of criminal force, the force being cut short before the blow actually falls. It seems to consist in an attempt or offer by a person having present ability with force to do any hurt or violence to the person of another. An assault is An assault includes in every use of criminal force.
Welcome. An assault consists in an attempt or offer by a person having present ability with force to do any hurt or violence to the person of another. Striking at another with a cane, stick, or fist, although the blow misses, drawing a sword or bayonet, or throwing a bottle or glass with intent to wound or strike, presenting a loaded gun at a man with, within range, or any other act indicating an intention to use violence against the person of another is an assault. Battery is defined to be any least hurt or violence unlawfully, unwillfully, or culpably done to the person of another.
Assault ingredients. This section requires two things. One is making of any gesture or preparation by a person in the presence of another. Second one is intention or knowledge of likelihood that such gesture or preparation will cause the person present to apprehend that the person it is about to use criminal force to him. Makes any gesture or any preparation. It is an assault to point a loaded gun at anyone. Mere utterance of, important point here is mere utterance of some threats unaccompanied by any gesture or preparation suggesting intention to use criminal force does not constitute this offense. Where the accused went away threatening the officer that he would return and teach a lesson, and soon afterwards he did came back, argued with a lathi along with some other persons, and came.
Sufficiently close to the officers so as to raise in his mind a reasonable apprehension that actual force was likely to be used. It was held that the act of the accused came within the definition of assault. To satisfy this section, the apprehension of the use of criminal force must be from the person making the gesture or preparation, and if that apprehension arises not from that person but from somebody else, it does not amount to assault on the part of the on the part of that person. Further, according to Section 128 of BNS Act 2023, corresponding law section is 349 of IPC, criminal force cannot be said to be used by one person to another by causing change in the position of another human being, where therefore the accused himself did nothing which could come under the definition of assault, but simply made a gesture at which his followers advanced a little forward towards the complainant in a threatening manner. It was held that he was not guilty of assault under Section 132 of BNS Act. Corresponding law section is 353 of IPC. Intending or knowing it to be likely. Intention is the gist of the offense. The gesture or preparation must be of such a nature that the person in whose presence it is made should apprehend that criminal force would be used to him. Throwing stones or bottles among the inmates with the intention of hurting or frightening them constitute assault. Important point. Mere words do not amount to an assault, but the words which the party threatening uses at the time may either give his gesture such a meaning as may make them amount to an assault. In the latter case, the effect of the words must be such as clearly to show the party threatened that the party threatening has no present intention to use immediate criminal force. A preparation taken with words which would cause a person to apprehend that criminal force would be used to him if he persisted in a particular course of conduct does not amount to an assault. There must be evidence to show that the accused was about to use criminal force them, and they.
Evidence proof that the accused made a gesture or preparation to use criminal force. Second one is that the same was made in the presence of the complainant. Third one is that he, that is accused person, intended or knew that it was likely that such gesture etc. would cause the complainant to apprehend that such criminal force would be used. Fourth one is that such gesture etc. caused the complainant to apprehend the same. Fifth one is that the accused received no grave or sudden provocation from the complainant. The words used and the preparations made by the accused were calculated to cause that person to apprehend that criminal force would be used to him. Sixth one is that the accused used force to the complainant. Seventh one is that he did so intentionally. And eighth one is that he used such force without the complainant's consent. Ninth one is that he did so in order to commit an offense he would likely to cause injury, fear, or annoyance to the complainant. Tenth one is that he received no grave or sudden provocation from the complainant. Gesture in communication. Emotional expression. General classification of 4 types of hand gestures are: one is beat, second one is dialectic, third one is iconic, and fourth one is metaphoric. standard of proof that there is no other logical explanation for the events other than the other than the guilt of the accused. Again, that there is no other logical explanation for the events other than the guilt of the accused. Direct evidence, eyewitness testimony, video, or photographic evidence. It directly proves a fact without needing further inference. Circumstantial evidence, physical evidence, tire marks, body fluids. Testimonial evidence, eyewitness, victims, expert witness. Documentary evidence, photography, medical records, and police reports. The prosecution must prove their case beyond a reasonable doubt.
Punishment part. Section 131 of BNS Act. Punishment shall be punished, that is, accused shall be punished with imprisonment 3 months or with fine or with both. Fine is rupees 1000. This is cognizable offence, violable, triable by magistrate. This video is purely theory. The Honorable Court decides each case on merits. Thank you.
Thank you.